Well, good morning, everyone, and welcome back to AJ111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. This morning's lecture is going to cover Chapter 13, where we're going to take a look at the courtroom, specifically the pretrial and the trial process. So one of the more interesting things is would be jury instructions and how that really relates to the jury. How does the judge get that across? And we'll talk a little bit more about that, but also the verdict. So when everything is done and the trial reaches the crescendo at the end, the verdict is read. So I want to open this morning's lecture with a very quick video on the reading of the verdict from the George Zimmerman case. And if you don't remember this one, this is a really good case study because this individual, George Zimmerman, was kind of a self-proclaimed, what do you want to call it? He wanted to be a law enforcement officer, but it was more like a neighborhood watch kind of thing. And he kind of touted himself as being like the neighborhood watch captain or person in charge, if you will. So this is the case of the state of Florida versus George Zimmerman. And this was, of course, the criminal prosecution of George Zimmerman on the charge of second-degree murder stemming from the shooting of Trayvon Martin. And this was back on about February 26, 2012. So on April 11th, 2012, Zimmerman was charged again with second-degree murder of the shooting death of 17-year-old Trayvon Martin. And this case was decided on about, I think it was July 13th, about 2013. But anyway, let's go ahead and watch the video. Then we'll have a pause, and then we'll jump into the lecture this morning.
Please be seated. Members of the jury, have you reached a verdict? If you'll please fold the verdict form and hand it to Deputy Jarvis. Okay, if you'll please publish the verdict.
In the Circuit Court of the 18th Judicial Circuit in and for Seminole County, Florida, State of Florida versus George Zimmerman. Verdict: we, the jury, find George Zimmerman not guilty. So say we all four-person.
Does either side want to poll the jury?
We would, Your Honor.
Okay, ladies and gentlemen, as your juror number is being called, please answer whether this is your verdict.
Juror B29, is this your verdict? Yes. Juror B76, is this your verdict? Yes. Juror B37, is this your verdict?
Yes.
Juror B51, is this your verdict?
Yes.
Juror E6, is this your verdict?
Yes.
Juror E40, is this your verdict?
Yes.
Thank you.
Ladies, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror could ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you an unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Is there anything we need to take up before the jury before they're sent back to the jury room to be discharged?
No, Your Honor.
No, Your Honor, thank you.
Ladies, thank you very much. You will be taken back to the jury room to be discharged.
Okay, so we're back after the video, and I hope you found that interesting. Now, of course, different states do things just a little bit different, and we've talked about that. But think of a few things. First of all, the impact of the verdict, of course. And then secondly, is there a chance for an individual, if they would have been found guilty, would they be able to appeal? And we've talked about that a little bit as well. Also, the number of jurors. In some, in some states, six is an okay amount of individuals. In California, if you don't know the number, well, I'll let you kind of stew on that a little bit and see if you can answer that and see how many people we typically have sit on a jury. But but what about something like five? Is a five-person jury constitutional? So remember, as we start to get into our discussion a little bit, the 14th Amendment guarantees the right of trial by jury in all state non-petty criminal cases. The court in this particular case that's on your screen now, in Duncan versus Louisiana, and this is back in 1968, applied this Sixth Amendment right to the states because trial by jury cases are considered to be fundamental to the American scheme of justice. Now, maybe not for something as simplistic, if you will, as a traffic ticket, but for those higher level crimes, those very those that are non-petty, as they said in the in the case. Now, when the court talked about the jury size in this particular case, when the court permitted the reduction in jury size, or to put it another way, when it held that a jury of six was not unconstitutional, it expressed reserving ruling on the issue whether a number of smaller than six passed constitutional muster or scrutiny, meaning six was kind of like right there, it was okay, but is five just too little? And the court in this case refused to speculate when this so-called slippery slope would become too steep. But we face now the twofold question whether a further reduction in the size of the state criminal trial jury inhibits the functioning of the jury as a institution to a significant degree or level, and if so, whether any state interest counterbalances and justifies the disruption so as to preserve its constitutionality. So I kind of say all of that, a little bit of legalese to say, what's a good number? And of course, you don't want to have too many. I mean, what if you had 20? Do you think they could ever actually reach any type of decision? But if they have too few, is it too easy to skew or manipulate or have people kind of go your way, if that makes any sense? So, this issue was addressed in this case, Duncan versus Louisiana. But again, what about the size of a jury? How many should really sit on it? Is five enough, or is it just too little? It's a very interesting question. So this chapter examines the pretrial and trial phases of the criminal justice process. And we're going to try to balance, again, between the interest of convicting the guilty and the fact that defendants are presumed innocent until proven guilty. And we do have to remember that a lot of times we kind of, wouldn't it be interesting to flip it the other way? What if, you were guilty until proven innocent? That would be what's kind of interesting, but it's also kind of scary. So the procedures during this phase of the criminal justice process also reflect the interest in public participation in the criminal justice system. So the government is required to establish probable cause in order to bring a case to trial, and we've kind of talked about that. And there are typically two ways, or it's a better word, procedures that are relied upon to determine whether the government may proceed to trial. And really quick, I want to back up because I just remember that I said something that actually sticks out as something important. So a couple of seconds ago, I said the procedures during this phase of the criminal justice process also reflect the interest in public participation in the criminal justice system. That means that citizens need to, volunteer for jury duty, or when they get that jury summons, to actually become part of it and try not to get around it. Now think about it. Come on. How many of you out there right now have received a jury summons and either made up some excuse or, which you shouldn't do, ignored it altogether? In order to make this work, we do have to have some participation. But okay, and I'll kind of get on you a little bit more about that later. But let's go back to the two ways or procedures that are relied upon to figure out or determine whether the government may proceed to trial. So the first one is the preliminary hearing, and that's typically what we would use out here in California and a lot of states. And this is where the prosecutor files what is basically called, in technical legal terms, an information. And that really is a written formal charge that is reviewed by a judge at the preliminary hearing. And the other process or procedure is going to be via a grand jury indictment. And this is kind of an interesting thing. So here, the prosecutor files a criminal complaint, and basically the grand jury, which is composed of ordinary folks like you and I, they decide whether to issue an indictment. And I'll show you what a indictment actually looks like as we go a little bit further in the lecture. So prior to the trial, the defendant may file several different types of pretrial motions, basically challenging violations of his or her constitutional rights. And these motions include, but certainly are not limited to, double jeopardy, and by definition we know what that is, speedy trial, improper venue, exonerating evidence, or unlawfully obtained evidence, which typically is the one that's used the most, if you will. So even when you look at some other high-profile cases, if you could look at the Cosby case, there's going to be a lot of pretrial hearings, maybe in this particular case, to block certain individuals from testifying, or to have certain evidence excluded before the trial begins, or or maybe to say that certain evidence was unlawfully seized, etc. So this is very, very typical in most trial cases. So following, or the next step, is the selection of the jury. And we're going to talk a little bit more about the preliminary hearing in a minute, but I just kind of wanted to get you in on the next step. So the next step would be, after the filing of the motions to suppress and etc., is to select the jury. And due process procedures are designed to ensure that the jury selection process is in fact free from discrimination and that the jury reflects a cross-section of the community. Now, keep in mind the important role played by the jury in protecting the defendant against unfair prosecution and also prosecutorial negligence or even abuse. So, I mean, this jury selection is very, very important. So, following the first appearance now, both the U.S. Magistrates Act and Rule 5.1 of the Federal Rules of Criminal Procedure provide that a preliminary hearing should be held within 10 days to determine whether the defendant should be bound over for trial or bound over to a grand jury. And most states, again, require that this hearing must be held within a reasonable period of time. And the purpose of this preliminary hearing is to determine whether there is sufficient evidence to subject the defendant to criminal prosecution, meaning actually continue with the charge of the suspect, or to actually, continue with the formal charging. And this is different from the first appearance, where the judge determines whether there is probable cause to actually justify somebody's detention, the prolonged detention. Remember, we talked about that. There's going to be a hearing, that probable cause hearing, to figure out, should we release the person pending trial? Should there be bail? Should they be released OR or own recognizance? Or do we keep them in custody pending trial? This is different. This is a separate hearing to determine whether there is sufficient evidence to subject the individual to criminal prosecution further. And in the legal sense, this means continuing to charge the suspect. So this preliminary hearing, first of all, the defendant has right to representation, because remember, they are entitled to representation at any critical stage. And I think last week's lecture, we talked about what are some of those critical stages. So they are entitled to representation. But this hearing itself is kind of like a mini trial. And it's not going to have basically the jury present at this particular time. It's not going to, both sides aren't going to call all of their witnesses. It's just going to be enough to basically where the judge can rule on whether the case should continue on. So again, the preliminary hearing is conducted as kind of a mini trial in which the defendant has the right to representation by an attorney, and the prosecutor will present some witnesses, not all, just a few. And in this little mini hearing, the witnesses may be cross-examined by the defense attorney, who also has the right to present witnesses in an effort to highlight basically some, maybe fatal weaknesses in the prosecution's case, maybe to show the judge that there are some weaknesses. Now, the magistrate will then determine whether there is sufficient evidence to bind over the defendant for trial, or whether the defendant should be released. So that's, and most states, when the court is trying to, level the standard, most states follow the probable cause standard. And that means that the judge will establish whether or not the case will continue based on a probable cause standard. And a couple of states out there still use this prima facie standard. So to kind of define them a little bit more, probable cause, here the judge determines whether there is fair probability based on the evidence presented during this mini hearing or this preliminary hearing, that the government will succeed in convicting the defendant at trial. And the issue, again, is whether there is probable cause to believe that a defendant may be convicted. So, I mean, that's a pretty high burden. So, but what's prima facie then? So this is different. So the Latin term prima facie means at first glance or at first appearance. And it is generally used to describe how a situation might appear on, let's say, initial observation. So here, using the prima facie standard, the judge determines whether the prosecution's evidence, if believed by the jury, is sufficient enough to convict the defendant at trial. So hopefully that kind of makes sense. And I threw in kind of a quick example. So here we have, Angelo has been charged with burglary of Stephanie's home. And at trial, the prosecutor must present evidence that Angelo entered into the home without authorization, which is one element of burglary. There are others, but this is one. Now, the prosecutor presents testimony that Angelo and Stephanie had an argument at work, and during which Angelo made some vague threats. And then a few weeks later, following the burglary, Angelo was found to be in possession of one of the items stolen from Stephanie's home. So what do you guys think? Is there enough to move forward with this case? Look at the two standards that I talked about. Probable cause, whether there is fair probability based on the evidence presented that the government will succeed in convicting the defendant at trial for burglary. Okay, prima facie, determine whether the prosecution's evidence, if believed by the jury, is sufficient or sufficient enough to convict the defendant at trial. These, it's kind of gray, isn't it? So, I mean, a couple of explanations. So while Angelo having possession of an item belonging to Stephanie is very, very suspicious, and maybe evidence to some other crime like being in possession of stolen property, it is not in itself evidence of the burglary. Does that kind of make sense? If there were no witnesses and no evidence that Angelo was ever in Stephanie's home, we may not be able to reach that burden. So the defendant here could request that the charge of burglary be dismissed, or the judge order basically what we call a directed verdict based on the prosecution's failure to present a prima facie case for burglary without ever even having to present any evidence on their own. So you can see how this kind of works, and you can see the difference. Okay, but on the other hand, if the prosecution presents any evidence that Angelo had been in Stephanie's house, so now we've got something else to bolster our case, like a fingerprint or an eyewitness account, the requirement of presenting a prima facie case has been met, right? And now it doesn't necessarily prove definitively that Angelo is guilty, but the defendant would need to present some type of evidence that disproves or disputes or causes doubt on Angelo's end. Does it make sense? Okay, so let's go ahead and move on. So that, again, that's the kind of the preliminary hearing a little bit as it relates to probable cause and prima facie. Now, the U.S. Supreme Court has held that a preliminary hearing is not required by the U.S. Constitution. And we're going to take a look at that because this is kind of an interesting thing. States are typically categorized as either indictment states, information states, or modified indictment states. And this is based on the role of the preliminary hearing in the state. So again, preliminary hearings aren't necessarily required. Okay, but we'll talk about a couple of cases that'll kind of clear this up. But let me give you the definition or tell you what each one of these are. All right, so an indictment state. So the 18 indictment states, including the District of Columbia and the federal government, provide that following the preliminary hearing, a felony charge is to be brought to a grand jury. And grand juries are the ones that issue indictments. Make sense? Now, information states, remember we talked before about the preliminary hearing, and when they file a case, it's called an information. So information states, prosecutors in 28 states may bring a felony charge based on a sworn statement, or what we call information, and then bring the charge either before a preliminary hearing or a grand jury. So, and we'll look at the court case that gives you the flexibility. And then you have what we call modified indictment states, and there are 4 states that require indictments for felonies punishable by capital punishment and life in prison. So what does this all mean? So again, kind of some interesting facts here. The preliminary hearing was developed because prosecutors would delay in bringing defendants before a grand jury, and because the judiciary wanted to ensure that defendants were not being detained without sufficient evidence to bring them to trial. So the preliminary hearing also, it is less time consuming, and it is viewed by most as fairer to defendants than that of a grand jury. So let's talk a little bit about grand jury, and we'll look at the Fifth Amendment on how this thing is kind of tied in, and things will start to kind of clear up a little bit. So let's talk about the grand jury. So the grand jury was thought to have originated in 1166 in the Assize Court of Clarendon. And the Assize was composed of 12 good and lawful men who were appointed in each community and who were in fact responsible for apprehending and presenting persons responsible for the commission of crimes to the royal courts. Okay, so does anything stick out that might have kind of morphed from then till now? So when you talk of 12 in California, how many jurors do we typically have? Okay, so how about 12? So you can start to see how things have kind of an interesting crossover, if you will, right? So, you know, it started off as this particular, you know, the good and lawful men, the 12. And this is kind of what it looked like back then. Now, as we start to go through a little bit more, at the adoption of the Fifth Amendment, every state required indictments for felonies before a grand jury. And some actually still do. But the importance of the grand jury in the political philosophy and the drafters of the U.S. Constitution is indicated by the fact that the Fifth Amendment provides, or it states in there, if you remember reading it, that no person shall be held to answer for capital crimes unless indicted by the grand jury. And by the way, if you want to know more, or qualifications, etc., I have a little link to the San Bernardino County Grand Jury, and you can kind of see, you know, what they do and what the qualifications are, etc. But again, this is the importance of the grand jury. But as we just heard, that utilizing the grand jury all the time, just, you know, it's not really the most fair process, if you will. and it bogs down the system, etc. So there really had to be something else. So, and here's the text in the Fifth Amendment: no person shall be held to answer for a capital or otherwise infamous crime unless presentment or indictment of a grand jury. Well, honestly, that wasn't going to work. So as we started to kind of, get a little closer to where we're at now, in 1884, in Hurtado versus California, the U.S. Supreme Court actually took this up and addressed whether states are required to provide a grand jury indictment every single time. And the answer at the end of the day was no. Basically, the state can use either the grand jury or they can hold that preliminary hearing. So now I hope that kind of circles everything back around, and it basically kind of makes a little more sense now. And I can go over it a little bit more, but just kind of finishing up, the court in Hurtado stressed that it was concerned with ensuring fundamental fairness, and that this principle of liberty and justice was adequately protected by subjecting a defendant to either the preliminary hearing or the grand jury. So this case actually gave us both. So we kind of have, states can have a choice, if you will. And a couple of other cases that came along that supported some of these. There was a case, Vasquez versus Hillary, that talks about automatic reversal rule if there is any discriminatory selection of grand jury members, just like if there were any type of discriminatory issues relating to selection of regular jurors. And we'll talk more a little bit about that. So following just to give you a little bit more information about the grand jury, following the selection and empanelment of the grand jury, the judge explains the role of the jury to the jurors. And the judge then releases the jury to carry out their responsibilities and does not participate at all in the deliberations. Now, the grand jury, in theory, is an independent body that may pursue its own investigation. But the reality of the grand jury is that the prosecutor exercises almost complete control over the process of deliberations in this hearing. The prosecutor typically submits an indictment. I'll show you what one looks like in a minute, or a written accusation that an individual or individuals have committed a certain crime. And Rule 7 of the Federal Rules of Criminal Procedure provides that an indictment must be a plain, concise, and definite written statement of the essential facts constituting the offense charged, and must be signed by an attorney for the government, along with the foreperson of the grand jury. The prosecutor then presents the witnesses and the other evidence that the jury should consider in determining whether the person who is the subject of the indictment should be brought to trial. Now, the grand jury does not depend entirely on the prosecutor and does retain authority to call witnesses and to ask their own questions. This is just like, in some smaller hearings, it's a non-adversarial procedure in which the defense lawyers and defendants are not present. So now when you hear that, remember, think back to what I said, that a lot of times grand jury indictments were not viewed to be fair, because in this hearing, the defendant nor the defense is there. So, I mean, that kind of takes away the adversarial part. Even in a preliminary hearing, there still is a little bit of adversarial process in there. And then the grand jury, at the conclusion of the investigation, may take several different actions, if you will. The first is to return what they call a true bill. And this is where the grand jury agrees that a person has committed a criminal offense. And they return basically what is known as a true bill that indicates that the vote of the grand jurors supports the indictment. Or it could be a no bill. And here's where the grand jury decides that the evidence does not support that the person should be brought to trial, and they issue a no bill. Or they have what is called a presentment. And here is where the grand jury votes to undertake an investigation that goes beyond the indictment and may issue what I called a presentment. And this is often termed a runaway grand jury. So the presentment is a report filed with the court that may name the individuals who the jury finds engaged in criminal activity. So it's kind of weird, isn't it? So, I mean, yeah, it's just kind of some interesting different things. So a grand jury, they apply the probable cause and prima facie tests as discussed in the previous, when we talked about earlier. And in the vast majority of cases, juries issue a true bill. It has been remarked that a prosecutor could persuade a grand jury to basically, kind of jokingly, they could indict a ham sandwich, because there's no adversarial process really. So, and there are some powers that the grand jury possesses. But let's look at a copy of the indictment. So here I have a copy of the indictment, and I don't know if the next page has a bigger one. No. So let me see if this will open up. Sometimes this works, sometimes it doesn't. So here's what an indictment looks like. So you can see, here's the indictment. Now this one, if you remember the case against Michael Vick and the dogfighting issue. Here's the indictment, the count. It gives some information about the case and then some other facts. And then when we get all the way to the bottom, if we can get there, here's all, it's just a lot of information in there. Kind of a timeline. And then here, it was a true bill. So in this particular case, they did find the indictment to be true. So that's what an indictment actually looks like. So what do you see as are some problems with the grand jury? One of the problems is that you do have some unqualified individuals to determine probable cause because they're just regular lay people. So that could be, an issue. It's non-adversarial, as I said before, so the defendant has no ability to challenge whatever facts are presented by the prosecutor. And I mean, so that's kind of tough. Those are two of the big ones. So just really quick, let me tell you what the grand jury possesses, and then we're going to kind of go into the arraignment phase. So the grand jury does possess powers that make it a particularly powerful arm of, of the prosecutor in investigating criminal activity. So again, we talk about the, defense attorney. An individual called to testify may not bring an attorney to the hearing. Right against self-incrimination, the grand jury may prevent an individual called to testify from relying on his or her Fifth Amendment rights by obtaining a judicial order granting the individual immunity from prosecution. Testimony: an individual has no right to testify before a grand jury, and there is no provision for the individual's lawyer to cross-examine witnesses appearing before the grand jury. As far as laws of evidence in the federal system and in most states, the laws of evidence are generally not applied, and grand juries can rely on hearsay evidence and unlawfully seized evidence. Exculpatory evidence. In many states, a prosecutor is under no obligation to present evidence favorable to the accused. So if the attorney, the prosecutor, has information that might be favorable to the defendant in a regular preliminary hearing before the hearing starts, that has to be turned over, and especially before trial. But as it relates to a grand jury, that doesn't have to happen. So, I mean, you can see it's not quite as fair. Subpoena power. The grand jury can compel individuals to testify by using the subpoena power of the court. And then secrecy. The grand jury proceedings are conducted in secret, and that's typically not how court hearings are held. The secrecy requirement is intended to prevent individuals who are indicted from fleeing, to ensure freedom in grand jury deliberations, and to enable individuals to testify without fear of retribution or tampering with witnesses, or to protect a person's identity, etc. So, I mean, a lot of information there on the grand jury, and there's a little bit more on page 480 in your textbook. But I want to kind of continue on, and I want to talk a little bit about the arraignment. And actually, well, yeah, let's go a little further. So I can see we're at about the 41-minute mark, so we'll go a little further. So once the decision is made to indict a person or to bind them over for trial, the next step is the arraignment. And at the arraignment, a defendant is brought before a judge and is informed of the charges filed against him or her, and is required to enter a plea. And there are basically 4 pleas. The first one is not guilty, which basically means I did not do it. I did not commit the crime. The second one is not guilty by reason of insanity, meaning I did not know the nature and the quality of my act. The next one is what they call nolo contender or nola contendere, depending upon your view of pronunciation. But this basically means that I do not want to contest the criminal charge. Now, it's still guilty. When someone pleads nolo, it is still cleared as guilty. But they just don't want to say it. That's really kind of what it means. Or they don't want to admit it in public, so they're going to plead nolo or nolo contender. Okay, and then finally, guilty, which means that I committed the crime, and let me describe the facts of the crime. So again, quickly, a plea of nolo contender or nolo contendere, or no contest, maybe you've heard that before, requires the permission of the court. And this plea, again, is used when a defendant, while not admitting guilt, doesn't dispute the charge either. And this plea, again, carries all of the consequences of a guilty plea, with one exception. The exception is that, unlike a guilty plea or criminal conviction, a plea of nolo contender may not be admitted into evidence in a civil trial to establish that the defendant committed an act that injured a victim and therefore is civilly liable to pay damages to that victim. So maybe you can see why there might be some strategy on the side of pleading nolo. All right, so we're right about the 45-minute mark, so we don't want to rush it. We're having a great time. I'm having a great time. So let's go ahead and take a break, a very quick break. You can, freshen up or what have you, and then come on back in a couple of minutes, and we'll finish with part 2. So this concludes part 1 of chapter 13, the courtroom, the pretrial and trial process.